Yes, you were under arrest. There's a warrant for your arrest. And the officers are going to get with you on this. 25 CR 1228. Are you, you're Kenlon Falk? All right, Mr. Falk, you were charged here in 25 CR 1228 with the second degree felony of aggravated assault with a deadly weapon. Do you understand? Which carries with it up to 20 years in prison. Because this was handed up back in September by the grand jury. And this goes on to allege, though, that you were convicted of robbery 2 times in the 252nd District Court on the same day, May 24th, 2002, long ago. After those 2 convictions were final, it is alleged in the indictment that you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony, and you were subsequently convicted of that on February 21st, 2019, also in the 257. So if all of this is true, you are looking at habitual felon status, no less than 25 years, no more than 99 years confinement in prison or life in prison is what you're facing. You understand? So that's what the guy was facing yesterday in yesterday's trial, who got 55 years in prison. You are under arrest at this moment. Do you understand? Yes, you are under arrest. There's a warrant for your arrest. And the officers are going to get with you on this, and they will be able to talk to you about it. But this has popped up, and you got to answer for it. We're gonna make a copy for you so you can have a copy of it. But your bond is revoked due to this warrant. And what was his bond before? What was your bond on this?
I think it was 20,000.
20,000 for habitual felon and committing aggravated assault.
Judge, I believe the issue here is the case was filed and dismissed, and I believe he bonded out on that first filing. And when it was dismissed, there was no warrant, and he didn't bond out on the new indictment. So I believe that's what's happening today.
That's correct. He has no bond on this new indictment. Yeah. So he's just to make bond.
So
I don't find this bond enough at $25,000 anyway. Who said the bond? Bad. But you are a habitual felon, sir, and these are 2 prior violent crime convictions, and then a serious illegal possession of a controlled substance, and now this is aggravated assault by threatening to use a deadly weapon, namely a vehicle. So your bond is increased to $100,000. There's a way to avoid all of this, is to not to commit crimes. And if you post a bond, you will be at home confinement. You must have a GPS device. You cannot leave the home except to and from work, most direct route possible, to and from hospital care, to and from acquisition of food. And those are the other purposes. And that's the way it is. Do you have an attorney?
also,
Are you unable to hire somebody to fill out an indigent form, and an attorney will be appointed to represent you? We'll appoint somebody today from the public defender.
So, sir,
You're taken into custody. That's the rulings of the court.
Sir, can I say something?
No, sir.
My boys in the back.
Sir, your bond is too low.
Shutting down all argument, the judge declares the defendant a danger to the community. Bond is sharply increased, the rules are made crystal clear, and the courtroom is reminded that public safety comes first.
Sir, follow the rules of the court. Thank you.
We'll just get her to fill out the indigent report for the jail.
Next is Jaquan Lazard. Next is,
Guilty.
As to the assault and battery, how do you plead?
Your Honor, I'm sorry to interrupt the court. It was brought to my attention that I had put a little bit of a different offer in writing to Mr. Carter. I don't know if I did that inadvertently, but I will honor that. And that would mean that would change it to him pleading to still the added count of an attempt R&O with dismissal of the balance of charges.
Well, he didn't know that. You didn't know that?
He
I'm
did.
asking him. You can't tell me what he knows. I'm talking to him. You didn't know that?
Yeah, I did.
So why you ain't say that? And when I said if that's your understanding of the offer, why you say, Judge, that's not what they told me?
No.
You don't think you got to protect yourself out here?
Yeah.
You got to do better. You got to get a belt and you got to protect yourself.
Okay.
You understand that?
Definitely.
Okay, so we're dismissing the assault and battery?
That is correct, Your Honor. I apologize.
No worries. As to the attempted resisting obstructing officer, how do you plead?
Guilty.
And that's because you believe you're guilty of that?
Yes.
Are you sure?
Yeah.
Factual basis.
Mr. Robinson, on or about December 15th of 2025, were you in the city of Lansing?
Yeah.
Ingham County?
Yeah.
More specifically, 3933 Phoenix Drive?
Yeah.
And at that time, did you come in contact with police officers as they were investigating a call that they received?
Yes, ma'am. Yeah.
And at that time, were you in a altercation with a Mr. Johnson?
Yes.
And the officers gave you commands to stop and you did not immediately stop?
Yes.
And they actually ended up having to say that command more than one time, isn't that correct?
Yes.
And you refused to do it at first, correct?
Yes.
I have nothing further.
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. I your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing March 6th at 9 o'clock in the morning, okay? We're gonna go downstairs and check in with probation before you leave here today, and they'll get you scheduled for a pre-sentence interview. You have any questions at this time?
No.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you.